You want to test it? Hey, good morning. Are you able to hear us from this end? Yeah, great. Thank you.
We're at 10 o'clock. Yep. Good morning, everyone. Good morning, everyone. It's 10 o'clock. Time for our scheduled Nevada Commission on Ethics meeting. Executive Assistant Pedroza, has our agenda been posted in accordance with the open meeting law?
Yes, it has.
Thank you. Let's go ahead and call the roll. Mr. Scherer is here. Vice Chair Wallen.
Here.
Commissioner Langton.
Here.
Commissioner Lowry.
Here.
Commissioner Miller. Here. Commissioner Moran.
Thank you, Mr. Chair.
Is there on Zoom. Commissioner Reynolds.
Here.
And Commissioner Smith has been excused. She had a conflict that she couldn't avoid. That brings us to the public comment. Oh, I'm sorry. Let's, will you please join me for the Pledge of Allegiance? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Yeah, and the staff roll call, Executive Director Armstrong.
Here.
Commission Counsel Bassett.
Here.
Investigator Terry. Is not here today. Senior Legal Researcher Hazlett.
Here.
And Executive Assistant Pedroza.
Here.
Executive Director Armstrong, have we received any public comment in advance of the meeting today?
We received one public comment, although it looks like that public commenter was able to make the Zoom, so I'll defer to his oral public comment. The written public comment we will include in the minutes package as part of this meeting, but I noticed he's here.
Yeah, I have received it, and I think the other commissioners have had access to it as well. Let's Executive Assistant Pedroza, other than Mr. Church, who I see is online, or anyone else who's submitted public comment or is present, wants to make public comment either online or?
No,
Okay,
there's no one else who indicated they would like to make public comment on Zoom.
good, thank you. So let's go ahead, Mr. Church. We know we've gotten your email. You'd like to go ahead?
Thank you very much. Yeah, my name is Jeff Church. I run a couple websites, RenoTaxRevolt.com and WatchdogJeff.com. Three different issues I want to gloss over kind of quickly because I know time is limited. Number one, so often we see that the individual that works for McDonald Carano has to recuse herself because of conflicts. McDonald Carano represents so many agencies statewide, both lobbying and legal, that it's just an obvious, to me, no-brainer that it just doesn't work, and it denies people the access to having another commissioner look at those issues. Number two, and it's in the handout that I provided, it's so frustrating time and time again to see that you issue a confidential letter of instruction, warning, fill in the blank. It's like being half pregnant. You either violated the NCOE rules, NRS, or you didn't. And oh, you didn't violate them, we're going to dismiss it, but we're issuing you a letter of caution, a letter of warning, etc. And when I read those that I can, it does seem there's probably a violation. So time and time again, it seems that the commission's not doing their job. And I'm trying to be polite, and it's frustrating to me when I read those. But again, it's just so frustrating. Then the third thing is related to that, the confidential letter issued to Ancho, which is hidden in the thing. Unless you spend your time going through it, you don't know anything what it's about. And that's only because Ancho said you could publish that part. Where you vote as a public official on benefits you receive. Normally it's healthcare, maybe other things, and you don't disclose it. It happens statewide constantly. So what do? You issue a confidential letter of instruction to Ancho, and it's hidden there. That word needs to go out far and wide to every official that votes on budget. Every time that I voted on the budget, if I got the healthcare, I would have been in violation. So please, just change course. Don't do these confidential letters of instruction. You're either guilty or you're not. You either violated or you didn't. And in terms of people voting for healthcare benefits, they need to disclose that. And by the way, they also need to disclose it with the Secretary of State in their annual filings. But it just seems frustrating again. And I apologize if I was a little too rude, but when you just hide it there in a regular decision that nobody ever looks at, and you don't publish it far and wide, and the violations go on daily. So I think my 3 minutes are up. I really appreciate the time and the opportunity and folks listening, and thank you very much for what you do.
We appreciate your comments. We look forward to seeing you at the future meeting. Let's move on then, if no other public comment since then. Okay.
Right.
Approval of the February 19th, 2025 commission meeting minutes. Has everyone had an opportunity to review the minutes? Does anyone have any questions or corrections to the minutes?
I move that we approve the minutes of the February meeting.
Second.
Any discussion? All in favor?
Aye.
Aye.
Any opposed? That motion passes unanimously. Next item is discussion and approval of discussion of a proposed stipulation for consent order concerning ethics complaint 24130C regarding Ron Boscovich, Commissioner, Nye County, State of Nevada. Will the attorneys for the parties identify themselves? Ms. Brewer, would you like to go first?
Yes, thank you. Rebecca Brew, Lemons, Grundy and Eisenberg on behalf of Mr. Boscovich.
And Ross Armstrong on behalf of myself as Executive Director.
Thank you. Mr. Armstrong, would you let us have your presentation, please?
Yes, the stipulated agreement that is here for your consideration today involves Ron Boscovich, a commissioner with the Nye County Commission. A complaint was filed on August 26th, 2024, alleging various violations of the ethics law, primarily with respect to his use of position and involving his ex-spouse and his daughter, both whom are employees of Nye County. The commission accepted jurisdiction and investigated 400 subsection 2, which is unwarranted benefits, and then 421 and 3, which are the disclosure and abstention rules within the ethics law. Commissioner Boscovich, during this process, agreed to waive a review panel. So there was no review panel in this case. There was like an early settlement offer to which we negotiated and agreed. The terms of the agreement that is before you today is that Mr. Boscovich and the commission agreed to one violation of NRS 281A 420 subsection 1, which is the disclosure requirements. That violation be willful based on the factors of 281A 775. In particular, Mr. Boscovich had received previous information from the commission about how to handle his relationship with his ex-spouse. And In addition, you know, we confirmed that he had a commitment in private capacity to his ex-spouse, Mr. Wagner, and his daughter Ronnie. The compliance period for this one is 1 year. This is a consent order, which after 1 year, if he's able to have no ethics issues, that will go from a willful violation to a non-willful violation. You've considered sometimes at review panels and in full stipulated agreements like a deferral agreement. This is different than a deferral agreement. A deferral agreement at the end, there's no violation at all and the case is dismissed. In this consent order, it's just adjusting that willful violation down to a non-willful. In some of the reasons why that's appropriate, I'll say in a lot of disclosure abstention cases, we do mentioned in public comment, a letter to let people know first. These have some different things, but what I will say is, you know, we provided Mr. Boscovich with the notice of investigation. We started the investigation. He, along with his counsel, reached out to try to get a good understanding of what to do in the interim, like how to fix the error. So there was a lot of, not so much self-reporting, but self-correction. We have observed Nye County Commission meetings since this case began where Mr. Boscovich has successfully done an appropriate disclosure based on this relationship. And so that is why the recommendation after 1 year of monitoring, if he's able to continue to show and prove to us that he can follow the rules regarding disclosure and abstention, that it be reduced to a non-willful. In similar prior cases, I'd say like a recent disclosure abstention case that we handled was in regards to Leo Blundo, who's a Nye County Commissioner. In that case, he did not properly disclose when the commission was increasing money that his private business would have access to under COVID relief funds. And that included, you know, willful violations of the ethics law. So this was the main meeting at issue was a approval of a budget. Both of his relatives are employees, and so they stood to have financial gain. They didn't get any specific financial gain. It wasn't specific bonuses for his daughter or his ex-spouse, but that was the issue. And so that is why the parties came to an agreement of an initial willful violation, and then if there's proof of continued compliance, to reduce that to a non-willful. So I'm happy to answer any questions you may have at this time.
For the record, it's my understanding there's a training component here as well.
Thank you. There's not a training component with Mr. Boscovich, but he is going to seek an advisory opinion to get clarity on how to handle his ex-spouse was a director of a department. His ex-spouse is now the county manager, and so there's new interesting questions that will come up regarding that. So there is a requirement that he seek that advisory opinion from us, so he has clarity on what to do. Oh, and he will successfully complete ethics training through the Nevada Ethics Online.
Ms. Brew, any comments?
No, well, I say no, like every good attorney, I say no, and then I just start yapping. I do want to say that I sincerely, and as does Mr. Boscovich, sincerely appreciate the efforts that Mr. Armstrong made. I think that he recognized that Mr. Boscovich truly wanted to be in compliance and just had a really hard time wrapping his head around how he can do that in the context of him having two relatives who, you know, worked then, and Mr. Boscovich is now the chair of the Nye County Board of County Commissioners, and now Mr. Wagner, his ex-spouse, is the county manager. So he really wanted to get in front of that, and I think there was some misunderstanding from Mr. Boscovich about what Mr. Armstrong told him, but Mr. Armstrong went out of his way to provide his time and assistance to educate Mr. Boscovich, and I don't think we'll see this happen again. I think he truly understands. So thank you, Ross, for the time that you spent. And with that, I appreciate your consideration.
Any questions from commissioners?
I don't have.
Do we have do we want to make a motion?
I'll make a motion. I move to accept the terms of the stipulation for consent order as presented by the parties and direct commission counsel to finalize the stipulation in appropriate legal form.
I'll second.
Commissioner Miller seconds that motion. Any other discussion? All in favor? Aye. Any opposed? Please let the record show it's unanimous.
Thank you. Thank you very much.
Thank you.
If you don't need anything else from me, I'll move on to the next excitement in my day. It's downhill from here.
I know the feeling.
Thank you.
Thank you. That brings us to item number 5 on our agenda, which is discussion and approval of a proposed stipulated agreement concerning ethics complaint number 24-168C regarding Dwayne McClinton, Director, Governor's Office of Energy, State of Nevada. So Mr. Ott is present?
Is this okay?
That's fine, yes. So Vice Chair Wallen and Commissioner Moran and Smith served on the review panel for this matter, and they are precluded from participating in any further proceedings. Executive Director Armstrong, you have a presentation on this particular stipulation.
Yes, so this is 24-168C. In October of 2024, the commission initiated a complaint on its own motion regarding Dwayne McClinton, Director of the Governor's Office of Energy. The allegations included that Mr. McClinton took tickets to a Golden Knights game and a exclusive partner party while the Vegas Golden Knights were attempting to secure sponsorship and funding from his department. And that also he had failed to disclose that gift as he engaged in establishing a summit and attempting to get the governor to attend that energy summit. The panel, we conducted an investigation. The panel determined that there was sufficient evidence to refer this case to the commission. The parties then attended a settlement conference, and in discussions following that settlement conference came to this proposed stipulated agreement. That is that Mr. McClinton will agree to a willful violation of 400 subsection 1, which is our prohibition against gifts. The other provisions of the ethics law will be dismissed. So 402 and then 421 and 3 will be dismissed. He agrees to pay back the estimated value of the ticket he had, which was $450, and that he will ensure that he gets training for himself and staff within 60 days. He will also receive an admonishment from the commission for his conduct. Some of the reasons in terms of the willfulness violation and why the parties believe this is a just agreement. Mr. McClinton has no prior ethics history. No funding actually ever transferred from the Governor's Office of Energy to the Golden Knights, so there was no actual monetary gain by the gift giver. Mr. McClinton, believed that there was an agency interest in partnering with the Knights in this particular way. On the other hand, there was no mitigation or reporting of the gift on his Secretary of State financial income item. And so in terms of similar other cases, the commission in the city of Reno case 9678C indicated that the commission looks at the value of the gift and the intersection, of is there an intersection between the gift giver and the agency or individual's ability to make decisions that affect the gift giver. That one was about a movie theater tickets. And then in the commission case, Enrique Lopez was a state employee who received a coach purse and some other gifts who was found to have willfully violated the ethics law. So it is similar to that Lopez violation case. And with that, I'm happy to entertain any questions.
Maybe we might let Mr. Ott make a presentation here before we launch into questions. Would that be okay? Mr. Ott, please identify yourself for the record and then let us know your thoughts.
Certainly, Chief Deputy Attorney General Greg Ott, on behalf of Director McClinton. didn't have a presentation, but I'm happy to speak extemporaneously about sort of the way this came about. Have definitely appreciated working with staff on the settlement and kind of understanding where this fit. This one, just so you know, our office, according to the ethics rules, we don't automatically defend public employees. We have to make a determination that this was within the course and scope of their duties and it was done in good faith before we undertake representation. So that's an internal thing. I know that doesn't necessarily bear on anything that you guys do, but we kick the tires on it before we undertake representation. What was persuasive to us, and I think is reflected in the documents, is there was an effort on Director McClinton's part to evaluate what was going to be offered in this partnership agreement that the Vegas Knights were proposing. If you attend sporting events, you have an idea of what goes on. The billboards, the Zamboni that comes around that may be sponsored, different breaks between periods, different breaks between penalty kills or shootouts. All these things are sponsored by different entities. You can get some perspective of what goes on at a game just by watching it on TV, but you kind of have to be in the room to really see the full impact of what's going on. So the Knights approached Director McClinton. He thought this was a good opportunity to get the message about some of the good work that his office does out. When they offered the chance to observe this, he thought there was a educational benefit to him and his staff to be able to understand exactly what the partnership was going to look like. Having attended it, he did see that there was some benefit. You know, you understand what the light boards are doing here, what is going on there, how the crowd is reacting to things. So he believes that there was a benefit to the educational process. Having said that, there's obviously ways that you can get that benefit in ways that are more compliant with NRS 281A. That's why we're here with the settlement, not saying necessarily we did nothing wrong. But from the director's perspective, those opportunities to observe the process, to observe what was going on, had a benefit on the decision making. Ultimately, there was, as Director Armstrong laid out, there was no agreement reached, so there was no benefit conferred on the Golden Knights or the foundation. But the course of conduct reflected genuine interest on his part in thinking there was a benefit that could be conferred on the agency. And I think that the settlement reflects that he understands this was not the proper way to get the information that he legitimately needed. But coming from a private sector mindset, not necessarily a public sector mindset, he didn't necessarily see those flags when he should have. And so that kind of gets us where we're at, where we're undertaking the representation because we do believe there was a good faith efforts within the course and scope of his duties, but yet there could still be a violation that we're agreeing to. So that's my extemporaneous presentation. I'm happy to take questions and again, appreciate working with Director Armstrong. He's always great at educating us on cases that were similar and why they're viewing things a certain way. He mentioned we didn't necessarily come to agreement at the settlement conference, but continued to work with each other in good faith to get to what I think is a good resolution for all concerned.
I've got a question for Executive Director Armstrong. In the Lopez case, I think you said, what was the penalty there? What was the financial penalty there?
Look that up real quick.
I can.
Yeah,
It was a single willful violation and $1,000 penalty.
That was more than the value of the coach purse?
Yeah, I mean, according to the agreement, the opinion, they found the value of the coach purse to be $100. And but there were also several lunches, but.
Okay. Other questions from?
I have a question of Mr. Ott. How many tickets did he get from Golden Knights?
2 tickets.
2 tickets?
Correct.
How come 2 if he was going there for educational purposes?
That was the offer that was made. It was, they said, hey, would you like to come and experience a game? We will get you 2 tickets, and they gave him a list of items. He accepted, didn't say, oh, no, I just need one or whatnot. Honestly, I think that's one of the reasons that we're here at settlement and not necessarily fighting harder to say that this was purely within this course's scope of his duties and he was entitled to go there to investigate. Because if there's only 1 ticket, then it looks like a much more legitimate effort of a director to go and evaluate everything. It's harder to explain the second ticket.
So under the settlement, is he repaying 1 ticket or 2 tickets?
He is repaying what we have determined, what commission staff determined was the estimated cost of 1 ticket. That was a point of disagreement in the settlement conference in terms of the value of the ticket. Like, we think we have a pretty solid case for the value of the ticket. In the investigation, the Golden Knights provided like the seat number, but not like a value. There's no like, here's your ticket, we value it at this level. So we believe we have enough evidence to say that the value of the ticket was around $450. In that discussion, you know, they thought it was less than that in terms of the value. So
Okay, I'm confused. Did he use 2 tickets? He was given 2 tickets, he accepted.
correct,
Did he use both tickets or did he use just 1 ticket?
both tickets.
Mr. Langton, were you finished? I'm sorry.
Pardon me?
Did you have other questions?
No, I do not.
Okay.
Thank you.
I have 1 more question, Mr. Ott. Mr. Reynolds, Mr. Ott, did Mr. McClinton, did he seek advice from his DAG regarding the use of wherever the 380,000 was going to come from? And if that was an appropriate use of those funds? Did he seek prior to that? Prior to this event?
Prior to the event?
Prior to attending the game.
So was there, okay, let me make sure I understand the question. Prior to the game, was there an inquiry with our office regarding the?
Or his legal counsel regarding whether he could use funds for sponsorship and, you know, directed at this type of event?
So I'm not the normal DAG for the Governor's Office of Energy. There was a different DAG assigned at the time. Getting to the fact where I'm gonna say I don't know the exact answer. I know that there were efforts to investigate whether the money could be done for the sponsorship. I don't know exactly. Mr. Armstrong may have a better idea because he's seen some of the internal communications. Usually when people are trying to figure out monetary issues, they first go to their fiscal team rather than come to our office because we do a lot with the legal issues, not necessarily as much with the fiscal issues. So normally it goes to fiscal first before it comes to us. I don't know if there was outreach or communication prior to the meeting. I do know there were efforts to look at whether there was an acceptable funding source.
And I can jump in on the timeframe. You know, on February 21st of 2024, the Golden Knights informed McClinton that 2 tickets were headed his way. On March 9th, he attended the game. It wasn't until March 22nd that the Golden Knights actually provided, this is the general cost of a sponsorship. And it was after that March 22nd email that you can see McClinton, and I think Mr. Ott is correct, primarily asking his fiscal team if there's a way to get the money for the Golden Knights for this purpose. I think there may be 1 or 2 emails where the DAG is CC'd on that back and forth about what may or may not be allowable. It's from the investigation, there's like discussion, there's no clear paper trail about like, this is when they decided it wasn't going to be done. It just, the communication on that end sort of falls off and then no money is ever transferred.
Commissioner Lowry, I see you've come off mute. Did you have questions?
I do, thank you. Can someone educate me? do I understand correctly that the underlying programs involved in this involved energy assistance to low-income families? Is that not accurate?
Yeah, I will say that that is based on the investigation that one of the sources of funding looked at for this was like winterization program within the department.
And is that an energy conservation program or is that a low income assistance program?
I did not get into like the exact details of that program, especially since the money never actually made it. We did not go far down that investigatory path.
Terry Reynolds, for the record, disclosure, the Department of Business and Industry through their housing division was a partner in the weatherization program, and there were grant funds and also matching state funds that went in to the program to provide for energy conservation and for weatherization programs. And there was a target for that.
Rachel,
Sorry, I'm just trying to, at a 10,000-foot level, understand the nexus between approaching that entity in the first place, if your program is a program for energy assistance for low-income families. That being said, I have a significant concerns in terms of consistency by the commission when it comes to the outcome and fines. When you look at the Las Vegas Visitor and Convention Authority case, I understand in that case, the people involved utilized, I think, Southwest Airline gift certificates. They did it over a period of time and did it multiple times. But that being said, in those resolutions, not only did they pay back the value of the gift cards that they unlawfully utilized, but they also paid some very substantial fines, I think thousands and thousands of dollars. So in terms of a case where you're taking 2 tickets valued at close to $500 a piece, that clearly violates the ethics laws, I have concerns about the commission being consistent in terms of outcomes, and also I don't think it's a significant enough consequence for the case.
Mr. Ott, Executive Director Armstrong mentioned that there was some dispute over the value of the tickets. What's your client's view of the value of the tickets?
Correct. Our estimation of the value of the tickets was $100 to $200. So it was significantly below what Director Armstrong valued them at. As I think everyone can understand, the value of ticket prices is not stuck in time, right? They sell for one point, and then the resale market may go up, may go down, depending on the teams where you are in the season, who may be resting, injuries, things like that. So it was a point of discussion and a point of disagreement. We eventually reached this number, which both parties agreed to after some discussion and polite disagreement.
And you did so for purposes of settlement?
Correct.
Thank you.
Executive Director Armstrong, do you know what seats they were? Do you have those?
Yes, section 6 section 6 row E.
Row E. Okay. Section 6 is.
It's right in the middle. It's
It's in I think they call it the lower bowl, or
I have section 11 tickets and they're 150.
Yeah, I'm in section 14, so that's, I was trying to estimate based on where I am, so that's, and they're about 150 as well, so, yeah. What's the, any other comments, questions? What's the pleasure of the commission? Commissioner Lowry said she wants to see a more substantial penalty. Other thoughts?
I think that makes sense based on the comments from looking at the chamber scenario, as well as even the coach purse scenario where there was a fine in addition to repayment.
Any other
Yeah,
comments?
I would agree with that. I think there should be a fine. I think appropriate fine would, in this matter, maybe, but I'll defer to the other commissioners, but I would think of approximately $1,000.
Any other thoughts? We have
My thought is that I think Executive Director Armstrong has done everything he could to effectuate a settlement, and I'm going to support the proposal because it is a settlement, and I've been involved in a bunch of them.
And I will say that I think the value, probably $450 is probably high. I guess my view is that he probably should have been at least repaying both tickets. Is that, and Mr. Otto, I'll invite you to correct me if I'm wrong, but my understanding is he didn't attend with another employee of the department.
That is correct.
Okay, so it was somebody personal to him as opposed to, again, the educational mission would have indicated maybe he took his deputy director or somebody who's over that program with him. So I think you ought to be reimbursing at least the price of both tickets.
If I could just add, Director McClinton's staff is entirely in the north, so there was no available staff member to attend with him. Not going to dispute the rest of your characterization about how that was not an official person, but it wasn't easy to effectuate a staff member to attend with him without incurring additional costs for either the agency or the staff member. So I think that's worth noting.
Understood. I guess my point was going to be that I think at least you ought to be reimbursing for both tickets. I think $450 is probably high and may actually be reimbursing for both tickets, but because I think they're probably in the $200 to $250 range a piece. At least the list price, the resale value is probably higher in many cases. But then if there's a and then the question is, should there be a fine on top of it? I also, as Commissioner Langton says, I'm somewhat torn because I agree probably based on our precedent, there probably should be a fine in addition, but also respect Commissioner Langton's comments about reaching a settlement and know that's difficult sometimes and needs to be respected. So do we have a motion from anyone to either approve or reject this settlement?
Well, I'll move to approve the settlement.
Do we have a
Proposed settlement.
Do we have a second for that motion?
Second.
Did you want to amend your motion or that? I think it's clear enough. Do we have a second for it? So I think that motion fails for lack of a second. Do we have a motion to reject the settlement?
I'll make that motion.
Well, let's see if we have a second for it first.
Second, and the question is, do we have to reject it in total or can we amend it?
My understanding is because it's negotiated, we would have to reject it in total and let the parties go back to the drawing board and see if they can reach a negotiated settlement we will accept.
So my second stands.
I think, sorry, this is executive. I think if there, I mean, I think it's right to reject the proposed stipulated agreement. I do think that we have in the past, if the issue is just on the penalty, right? And the commission says, you know what, if this penalty was 1,000, we would get to yes. I think, under kind of just the rules of Robert's Rules of Procedure, we could go to the next agenda item, provide Mr. Ott opportunity to contact his client and see, like, if that's the only hiccup, right? Like, if the willfulness sounds good, if the training of staff sounds good, but as a commission, you want a higher fine, you could give him time and then Mr. Rock could come back and say, we need more time to discuss that, or he could say, I talked to my client and my client is on board, then we'd have both parties in the commission. And I think, I'll defer to Liz as your counsel, but I think that that is something we've done before, is giving folks time to consider it.
If there's, I mean,
If that's
if that's
acceptable,
what the commission would like to do.
Mr. Ott, is that something you'd like to reach out to your client today to try to get this resolved, or?
So I'm not optimistic that I'll be able to get in touch with my client immediately. I'm happy to try. It will, I think, be helpful to me if I could understand the commission's concern. If it's being out of line with prior precedent, then to me, there's either, well, you change the settlement to come in line with precedent, or maybe we better explain why we think it is within those precedents. I understand the cases that that Director Armstrong cited. There's reasons why we agreed to this, and I might advise not to agree with something more substantial. So it will be helpful to me in conversation with my client if I can understand exactly what the reasoning is for the increase. And I'm happy to try either today or in between now and whenever a future meeting would meet, if there is, if the motion goes to reject. Apologies for answering more than your question.
Well, it sounds like we're not gonna get this resolved today, one way or the other. And I don't know if anyone wants to, we have a motion and a second on the table. I guess under discussion, I would say that my view is that the precedent has been to have some type of fine typically along with the reimbursement. I'm not sure that I necessarily feel like it. I mean, I think Commissioner Reynolds has suggested $1,000. I don't know that I necessarily would say that it needs to be that, but I think some type of fine, I think, would be more in keeping with precedent.
Yeah, I think there's options. You could say, you know, 450 for the tickets, which he's already offered, and 500 for a fine, or, you know, some combination thereof would be fine, but I think we need to reject the offer first and then renegotiate based on whatever we're at.
Yeah, I guess I'm just trying to give both Mr. Ott and Executive Director Armstrong some guidance as to where we are when we're in an open meeting and can discuss this as a body publicly. So I don't know if there's anybody else has any other comments or thoughts that they want to share.
I think a fine in 100% of the value of the tickets received would make sense.
Commissioner Lowry, did you have anything?
I'll just add that I am in support of the one willful violation and the training and the admonishment. So all those parts of the negotiation resonate with me. I would be inclined to support Commissioner Reynolds' original comment about $1,000 fine. So for me, it is about paying back the price of the ticket and an additional fine, and looking at the LVCA case.
And I guess to me, the Lopez case might be closer than, with all due respect, Commissioner Lowry, than LVCVA, because as you mentioned, that was a repeated violation in the LVCVA case, whereas I think the Lopez case, while there were some lunches, was a sort of a one-time thing, which is closer to me in my mind to this particular case. But I think that hopefully that gives you some guidance as to where the commissioners are with this. We have a motion and a second on the table. All in favor of the motion, please say aye.
Aye.
What exactly is
The motion is to reject the settlement, which would then allow Executive Director Armstrong and Mr. Ott to attempt to renegotiate, or if they're not successful, then we would be coming in front of the commission for a full hearing.
Okay, I support that.
Is there anyone opposed? Please show Commissioner Wallen and Commissioner Moran as abstaining, since they were on the review panel. And otherwise, it passes unanimously. Thank you.
Thank you.
But
That brings us to item number 6, report by the Executive Director on agency status and operations. Director Armstrong.
Thank you, Mr. Chair. Director Ross Armstrong, Executive Director. I've included a report with the materials, just some quick operations highlights. We had a recent interagency collaboration meeting with other state agencies that do government oversight. So the Division of Internal Audits and the AG's office, and just trying to figure out, are there ways that, you know, all of us who oversee other government entities can work and share information in a more effective way. As I'm sure you're aware, we get lots of like things that could be open meeting law complaints or public records complaints. And with the proposals in the legislature for an inspector general and for a public records ombudsman, I thought, oh, this is a good time to get together and see if there's some sort of collaboration. Most of us have very strict confidentiality rules. And so, you know, but maybe that is something to look at in a future session where we identify agencies where our confidentiality rules are laxed so that we have effective oversight of other government entities. So that was kind of an exciting thing since the last meeting. We have our plan for our senior legal researcher position, what to do with that. We will have Curtis will underfill our associate counsel position starting in May, and then would be able to auto progress up to the position upon passage of the bar. And then we have a law student who we can emergency appoint to the vacant senior legal researcher position at half time to help us over the summer during that gap and make sure we still have some folks to get the work done. So that we got that confirmed by HR this week that that's all allowable. So we have a good plan to kind of fill in gaps where they are. This is a month where we talk about the quarterly case log, which is provided to you. I will do a quick reminder that as commissioners, you have an unredacted version. There's lots on here that is confidential. And so if you have a question about one of them, it's best to identify it by the number. This new format for the case log is going to make the annual report a lot easier for us to get the data collected. I will tell you that we are timely processing cases. I think our oldest case in relation, let's see, I have that ready now. I think our oldest case that is investigating were items filed last June. There's nothing older than that. You know, when I first came on board, we had cases that had been in investigation status for 2 or more years. We're being able to process those in a timely manner. After today, we'll only have 5 open investigations. We're going to process 2 panels later today. We've got 7 cases pending resolution. So we're able to manage those cases from a purely not like verified by data check on me, just a gut check. We have a very healthy start to advisory opinions this year. I'd say we have a healthier start on advisory opinions than complaint cases, but I think overall we're right on track to where we are. There's not like a huge drop off in total volume, which is great. I mean, honestly, it would be great to get at a point where we have as many people asking us for advice than we do as complaints. Like that would be a great way to be serving the public. Legislative update, obviously, we're about halfway through the legislative session-ish. Been providing weekly updates for the commissioners and staff, so we're where we are. Both, I would say we were monitoring 2 constitutional amendments that had implications for the ethics law and ethics in general. Both of those failed to meet last week's deadline. And so those proposals are currently off the table. They can always appear magically through different ways through the session, but those 2 ones where Liz and I met with the sponsors and made sure that we are keeping those lines of communication open are done. We had an ethics presentation on March 25th. If you look at the outreach and education report, you can see some photos from that. Our budget closed on April 1st to include the following enhancements to our budget: a modernized case management system, some training and outreach subscriptions and resources to help SAM do their job, and then some COGL, which is our National Association of Ethics Agencies, travel. It had always been coded to the travel or to the, I forget where, to the training budget. Now it's like, oh no, that's actually out of state travel every time. And so they've just put it in the right thing and enhanced it a little bit so that we can send Sam and 2 other folks. We continue to monitor bills. The bills that are most likely to impact us are those that change open meeting law requirements or public records. So we're continuing to keep track of those. There's nothing in those that are really super red flags or items of concern for us, but we continue to monitor things regularly at the legislature. Work continues on the strategic plan. I'll have a much bigger update on that in June. Our budget is finally, our IFC request, as you remember, when I think we were last here at the State Bar in Reno, we approved a language access plan. A work program was produced so that we could get the funding for that. We thought it would be heard at this IFC, but then they said it can't because there's a legislative session, so it'll be heard at the June IFC. But we'll get some money for that. We also had terminal leave costs, and that work program has been completed to cover that at the end of the year. The new addition to the executive director's report this time is that I'm thinking a lot about process and every commissioner sees cases as they come in on jurisdictional determinations. And then 3 commissioners see a review panel. And we really don't let all the other commissioners know what happens in the review panel. So there may be cases where you're like, oh yeah, did we investigate that? And you're not sure if it's open or closed. And so I'm going to start adding the recent review panel determinations that happened since the last meeting to the report so that you have a sense of where those are. So you can see the February and March items there. And then our upcoming meetings in May will be panels only unless there's a need for a special meeting. In June will be in Ely, so we'll be reaching out about that coordinating that travel. And then in July will be panels only again. And then in August, we'll be back here in Reno. So at this time, I'm happy to answer any questions.
Questions for Executive Director Armstrong?
Just comment here. We did have a bill in, I think it was 2 sessions passed, that actually would allow us to pass things on to other agencies if it was in their area and stuff. So you might want to check with that.
Yeah, I'll look at that language. I also, I know one of the interesting things that is if the commission makes a determination that there's a violation, but there's maybe also criminal activity, we're required to refer that to the AG's office. And we've had bills in the past that say, at any point, if we determine there may be criminal activity, to refer it to the Attorney General's office. So again, those kind of interagency collaboration things, I think there's opportunity there. Like, I don't want to send every alleged open meeting law thing to the AG's office, right? They're buried in open meeting law things, but if there's like a serious, like if they're focused, policy wise on a particular type of open meeting law issue they want to resolve and we get a good case, like letting them know, figuring out if we can do that. I think especially the audit reports from LCB audit and from the Division of Internal Audits, we're now getting those directly to us so that we can kind of review and see some things and go, oh, let's go look at that. Yeah. So thank you for that comment.
And then I have a favor to ask. I mean, I could do it myself, but the other times we've got the case log, the more 2025 would be at the top and the other one would be at the bottom because it's, and being on my tablet, it's hard to sort it and get it how I like it. Plus you don't have the headings and stuff.
Yeah, we can work on.
If you can put those up sorted, so the more recent ones are at the top.
Yeah, we can definitely.
Because they used to be that way. I don't know what happened.
Yeah, we can look at some adjustments to make it more user
Well, if you
friendly.
just put the more recent ones at the top, so you have the headings to
where
look
they are.
at, yeah.
Okay.
That's my only comment.
The Excel sheet though, you can pull up
Hmm?
You can pull up the Excel sheet in the other app.
Yeah, but I'm just saying you gotta sort it and it's like
Yeah.
the pain on.
But she said she could do it herself.
Yeah, exactly.
I know, but it's
I
just
get
like, it's distorted. I mean, it should come that way anyways.
Yeah.
It used to come that way.
I have a general question is, if in your investigation you discover embezzlement, it just seems to me axiomatic that you would report it.
It's, I mean, I'm gonna have to consult with Liz on that because the information we receive is confidential. So do I violate our confidentiality law by sharing information before we legally can, I think is the.
Well, you would report it as possible embezzlement, I would assume, not a finding of embezzlement.
Yeah, the challenge would be providing the documentation that we've obtained as that's a part of our confidential investigative.
Yeah, but I'm not referring to documentation you have. I'm saying, hey, Sheriff Lombardo or whatever, you might want to look at such and such.
Yeah, I
don't know, It
can,
just seems
I can work with
the
Lynn to
logical
get
thing to do.
what those parameters would be.
Right.
Yeah. Covering up a crime I can't
No.
get behind.
I would think there would be normally be inherent authority. I agree with you to report that, but as Executive Director Armstrong points out, we do have a confidentiality statute, so I said, ask them, the two of you to confer and look at that and report back to us.
Yeah, we can,
That's why we need some legislation or something that would specifically allow us to do that, because I think normally it would just be, as Commissioner Langton said, something you would just do.
Right, well, yeah.
But I understand the confidentiality restriction.
It's not as easy
Yeah.
as that. And Ross, I think is correct on it, but a couple things that we've had to do in the past, Michael, this may answer your question on it. Is that we, if it's an employee or a state agency that we're looking at, we went through and worked with the HR office and also the DAG, who would basically consult with the AG's office in terms, because that's their employer, in terms of what level it rises to be able to handle the case. And there are cases that are where there is embezzlement, and they are reported through to the DA's office. Excuse me, the AG's office, and not, but there are also private entity issues that you see or dealing with, like a city or county, that goes to the district attorney's office. But there has to be a review investigation, and I think as that investigation process is confidential until you get to a conclusion. So it's and Ross, you've probably been through all phases of those, where you have to say still confidential, can't report it yet. If it becomes conclusive and it comes to the commission, then it is made public and goes to the appropriate law enforcement office.
so I will, for the next meeting, I'll meet with Liz and we'll figure out
Yeah.
what those, what our barriers are, if there are any, and under what circumstances we can.
And perhaps if we had a policy in place that would say, we
Yeah.
can. And maybe the policy might be, you do what we say, go to a public meeting so that it's no longer confidential.
Right.
Um,
Yeah.
So they can be reported.
Well, that is this topic is what we kind of tackled in that initial agency one, is like, what information do you have? Well, the state's waste, fraud and abuse hotline, right? Like, they think they can probably send that to us for like Aaron as our investigator to review and say, are there any ethics issues in here we should go pursue, right? They have to de-identify some stuff, but I think we don't currently have we have a policy on how to handle like public records requests, like when we get that. But one about what time and when we refer different things to different agencies makes sense for policy adoption. So we'll put that on the priority list.
Thank you. Other questions or comments? Let's move on to the next item on the agenda. We don't need a motion to have to step to the. So item 7 is the report on ethics, outreach and education. Executive Director Armstrong, I assume you're handling that.
Yes, this is Executive Director Armstrong. Sam is still out on leave and healthy and everything, so that's great news. And I think we'll be back for our next meeting, which will be great. But in the meantime, I'll do the outreach and education report. In terms of outreach, I think two big things that were big, not only because I think they were successful, but also because they were, I would say, our firsts to my knowledge. One, we had an ethics day at the legislature, so we had a table with Carrie had great ideas about which candy would be best associated with ethics, and so we ran with those like 100 grand bars and ferment patties for cooling off and such, so. We were there in the main lobby all day. For those of you that are here in Reno, you can see we designed like kind of a 50 years of Nevada ethics with major landmarks on it. Former Senator Hardy, who is now a lobbyist, was very thrilled to see his name on the board. We got a picture of him, pointing to his name, and so that was good. The other thing is that the Nevada Lawyer, the publication from the Nevada State Bar for attorneys in Nevada, their focus this month was on, thank you, Chris, was on public law. And so we were the first featured article in there that talked about 50 years of the ethics law. And we had good feedback from attorneys since then, like, oh, that was super helpful, and people appreciated that. There are other articles about open meeting law and some of the other stuff. I will argue that since they put us first, that means they think it was the best one. I don't know how they make those editorial decisions, but I'll choose to believe that. In terms of recent trainings on page 3, you can see I went down to Nye County and trained 40 folks there just last week after we submitted the materials to you, or I trained the Clark County DA's office, and we have some upcoming trainings in June and July. You can see we are in good shape compared to where we were last year in terms of training, which is big credit to Sam and coordinating those and doing a lot of those trainings, and also credit to the commission as it approves different stipulations with individuals who are like agency heads to say like, you should get your whole agency trained. That helps that number out as well. And then finally, on the last one, we're getting ready to produce our April newsletter and continue to develop what is an ethics ambassador toolkit. I think that last segment on page 4 of the report that was interesting for me to do this time with Sam being absent, because we never did this, and then Sam started and we did it. This is a good example of how adding that position has increased our capacity to know about what we're doing, is the public records request numbers and the request for information numbers. We had a lot of requests for information since the last meeting, and so it was interesting to go through and tally those up and see what they were about. And so I think that's a really good data point for us to have Sam keep reporting in terms of like, that's a really good picture of what that position does, not just the training and the tweets and all of the managing the online learning management system, but also like this is the stuff that other staff like Carrie, the SLR, the executive director, have had to do in the past, but is now handled by that additional position, which is great. And frees us up to do other things. So that is it for the education report. I'm happy to answer any questions you may have.
Questions for Executive Director Armstrong? Commissioner Lowry.
Sorry for the delay. Thank you. Not a question, just a comment. Thank you, Executive Director Armstrong. I thought the article in the Nevada Lawyer was excellent. It was a great historical overview. You did a nice job of selecting a group of cases to highlight. It was a really readable narrative on our mission and purpose, and a delicately crafted statement as to our relevance and importance today. So thank you for what you did.
Thank you.
Any comments or questions?
No, I liked all the outreach that we're doing. I mean, you look back to 2022 and, trained maybe 500 people. I mean, so, I like it. We're getting out there and stuff. We're talking about, I probably aren't doing it because Sam has been out, but we're gonna go and come up with some type of a survey so we can get some feedback from the general public on how they view us.
Yeah, that is in Liz's court. That's part of her.
Yeah. Okay.
That is on my list, yes.
All those
between-
advisory
yeah.
committees.
Between now and May, I'll make sure that happens.
Can I tell Commissioner or ask Commission Counsel Bassett to please let Ms. Bruno know that it's not just attorneys who say no and then go on and talk. Must just be human nature.
I'll let her know.
Have to defend the honor of attorneys.
Well, I said I don't have questions,
Comments.
comments.
Thank you. They were good comments. I appreciate it. If there are no others, that'll bring us to item number 8. Commissioner comments, just general comments, anything that you want to see changed, anything you'd like to have handled in a particular way, items that should be on future agendas?
No, I would just wanted to say, I know you've been very busy, Ross, and you will continue to be very busy until legislature ends, and but happy to sit down with you on the SharePoint issues that we discussed in the February meeting, and I can help you with some of those. So I think it works very well. I think there's some enhancements that we could put into it, but you know, it's up to you for your time. You have time.
Yeah.
Well, we're wearing 3 hats right now, so.
Yeah.
Any other comments?
No, I think the commission staff is doing a great job. And it's so nice that we're caught up.
Yeah. I will say, yeah, thank you, Ross, for wearing 3 hats. We appreciate your work. Congratulations, Curtis. Happy to.
Well, not yet.
At least
Thank you.
we have faith in you.
Positive thinking.
Yeah.
Appreciate that.
With that, I think that brings us to item number 9, which is our final public comment section. Jerry, do we have anyone online or any emails that we've received since we've been here?
We have not received any emails. We do have one, excuse me, one member of the public on Zoom. Mr. Church would like to make additional public comment at this
great.
time.
Mr. Church, please go ahead.
I'll be very brief. First of all, I appreciate Mr. Armstrong. He's always responsive. His professionalism is outstanding. So I know I'm a critic, but in this case, he's been very responsive. Very quick comment. On the confidentiality issue, it seems a no-brainer that you ask the reporting party to waive it. And if needed, you ask the accused party to waive it. And if they do, then that solves at least part of the problem. Thank you.
Thank you. Any other public comment? I don't see anyone else online. Mr. Ott is the only person from the public still here in the room. So with that, I think we're adjourned. We need a
I'll make
motion to adjourn.
adjourn.
Okay, do we have a second for that?
Second.
All in favor, say aye.
Aye.
Aye. No, any opposed? No. Mary, I'll let you decide who seconded that motion.
I have Commissioner Miller.
Okay, because Mr. Miller did it verbally, Commissioner Langton had his hand.
I actually don't even know if you need a second for your.
Yeah, well,
We like to overdone it.
there you go, overdue.
I know we have a review panel next. I'll ask Reynolds, primarily for Commissioner Lowry's benefit. Do you want to start that in about 10 minutes or?
That'd be great.
Yeah, so a break and then 10 minutes, Commissioner Lowry, and that's a different link for that as well.
Thank you.
Thank you.
Yeah, so she only has 2 cases. So she said-